Madam Speaker, I thank the gentleman, the chair of the Constitution Subcommittee, for yielding to me, and I rise in support of this act. And I'm a little bit astonished by some of the debate and the dialogue that's taken place here throughout this day, especially on the topic matter that is executive overreach. We've had extensive hearings in the Judiciary Committee, and it should be clear to all that when the liberal constitutional professors are concerned about our country, a tipping point in our Constitution, it's time for maybe a little bit more of an open dialogue here, and I think more of an objective dialogue. But I would bring to your attention, Madam Speaker, some language that was in the Wall Street Journal today. And it was in support to faithfully execute the Law Act and then the Reporting Act that we're talking about. It's a perfect example of why this bill is necessary in a report in the Wall Street Journal. It's what it says in today's issue, describing yet another Obamacare delay that flies in the face of the statutory text. And I quote, this latest political reconstruction of Obamacare has received zero media notice, and the Health and Human Services Department didn't think the details were worth discussing in a conference call, press materials, or fact sheet. And instead, the mandate suspension was buried in an unrelated rule that was meant to preserve some health plans that don't comply with Obamacare benefit and redistribution mandates. Our sources only noticed the change this week. Close quote from the Wall Street Journal. Madam Speaker, this is not the way Congress should be informed of the President's failure to faithfully execute the law, or his utter defiance of the law, or his executive endeavor to amend the law outside the bounds of his Article 2 constraints. No, Madam Speaker, Madam Speaker, no President, when the President or any other federal official adopts a policy of failing to enforce the law or refusing to enforce the law, it should immediately inform Congress in writing so the duly elected representatives of the American people can respond appropriately. And to have to find out in a newspaper article, or find out on a website, or worse yet, in one of the earlier unconstitutional overreach efforts of the President to amend the Obamacare law, we found out on a third-tier U.S. Treasury website. Now, what if 316 million Americans responsible to know what the law says and do our best to comply with it can be cruising around on a third-tier U.S. Department of Treasury website to see if the President has gotten up that morning or gone to bed late the night before, maybe a little bleary-eyed, and issued some kind of an order that there's going to be another amendment change in Obamacare. Obamacare. It has his name on it, Madam Speaker. The President's name, Obamacare, on the top and his signature on the bottom. And we had a constitutional review meeting this morning with constitutional scholars, and I said, is it 31 times that the President has, by the stroke of his pen or the word of his mouth, amended Obamacare? They corrected me. They said, no, it's 38 times. Now, I don't have that list. I hope I get that list, as I'd like to examine some of them that I am missing. But the President of the United States has authority to amend Obamacare. Yes, there is executive discretion on the implementation of it. But the starkest violation of the Constitution and the starkest amendment to Obamacare is the one that people agreed with. And it is this, that when the President announced that he was going to delay Obamacare, the employer mandate, for an extra year, when the bill itself says the implementation of the employer mandate shall commence in each month after December of 2013. Now, I don't know how the gentlelady from California's dialogue gets around the very, very strict language that was written into Obamacare. It doesn't say if the President changes his mind. It doesn't say if Democrats are vulnerable. It says shall commence in each month after December of 2013. Yet the President decided he would just simply delay that for a year. Now there are, what, 30 or 37, pick your number, different times the President has done this. I remember criticism from last summer when I was asked by the press and the public, and the demand from people on the other side of the aisle, Obamacare is the law of the land, so we are obligated to fund it through the appropriations process. That was a big debate here on the floor of this House. And I said then, we don't know what the law is, because the President has so stirred the pot with his executive orders, his executive pen, his cell phone, his ink pen, or his press conferences, that no one today knows what Obamacare is or says. And even if we think we knew, we'd have to be a contemporary scholar of the bill, and we couldn't go to bed tonight thinking we knew what it'd be tomorrow morning, because it's likely to change again. That is what's going on simply with just Obamacare. And by the way, I would add, conscience protection. When we were assured, and it was to be written into the bill, that the conscience protection would be there for those folks who had a concern, and the President...
Gentleman's time has expired.
The remainder of the time, Madam Speaker.
The gentleman from Arizona has 3 minutes remaining.
Okay.
And
No,
the gentleman
I would yield the gentleman an additional 30 seconds.
Okay.
I thank the gentleman. I want to make the point. The President even amended Obamacare by press conference, which is completely outrageous. Not to get to the immigration components of it. There's nothing in this that deports anyone. The things that we did with my amendment address the DACA language are also the President's overreach. And by the way, the prosecutorial discretion says on an individual basis only 7 times in that order, but it creates entire classes of people, 4 classes of people, encompassing hundreds of thousands of people. You can't describe hundreds of thousands of people as being individuals. They're groups created unconstitutionally by the President. And I would yield back and thank you and the Chairman.
Gentleman from